Her neighbor's restaurant ruined her life. Then came the lawsuit. She didn't throw a punch. She didn't vandalize property. She left a 1-star review and ended up in a courtroom fighting for $180,000. The woman who lived directly next door to a small Italian restaurant had been a fixture in the neighborhood for 11 years. She raised her kids there, watched the block change, and when the restaurant opened 3 years prior, she welcomed it with a basket of homemade bread and a genuine smile. For a while, things were fine. Then the summer crowds came, then the outdoor patio expansion, then the noise complaints started. 17 of them filed over 14 months, all documented, all ignored. So she did what any frustrated person with a smartphone does in the modern age. She posted. The video was 47 seconds long. In it, she stood on her back porch at 11:43 p.m. on a Tuesday, phone pointed toward her neighbor's property, capturing the unmistakable roar of a packed patio, clinking glasses, and a live accordion player who apparently had no concept of noise ordinances. She posted it to her neighborhood social media group with the caption, "This is my Tuesday night, every night. Someone please help." By Thursday morning, it had been shared 14,000 times. A local news station picked it up. The restaurant's name trended locally for 4 days. The restaurant claimed it never recovered. The owner, a second-generation restaurateur who had sunk his family's savings into the space, filed suit 4 months later, seeking $180,000 in compensatory damages for lost revenue, reputational harm, and what his attorney described as a deliberate and malicious campaign to destroy a small business. His financial records showed a 34% drop in weekend reservations in the 6 weeks following the video. Negative reviews flooded in from people who had never set foot in the restaurant. One vendor quietly declined to renew their contract. The owner testified that he had received threatening messages, that his staff had been harassed, and that his mother, who still worked the front desk on Fridays, had cried on the drive home more than once. His legal team argued defamation by implication. The video, they said, presented a misleading picture. It was shot on the one night the restaurant had exceeded capacity for a private birthday event, a permitted, contracted exception. The ordinary Tuesday night, they claimed, was nothing like what the video portrayed. The neighbor was unmoved. She brought records of her own: the 17 noise complaints, the letters to the city council, a sleep study conducted by her physician, and a child psychologist's note documenting anxiety in her youngest son that had emerged during the prior year. She wasn't trying to destroy anyone's business, her attorney argued. She was a mother who couldn't sleep, whose child was suffering, and who had exhausted every official channel available to her. The video was the truth. She had simply let the neighborhood see it. The court might have settled along predictable lines: free speech versus business harm, sympathy for the mother versus sympathy for the immigrant entrepreneur. But then the city's noise ordinance compliance database was entered into evidence. The restaurant had received 6 formal citations in the 14 months the neighbor had been filing complaints. Citations the owner had never disclosed in his initial filing. Worse, internal emails obtained through discovery revealed that the restaurant's general manager had explicitly discussed the neighbor's complaints internally and decided in writing that the cost of compliance was not worth the seasonal revenue loss. They had known, they had calculated, and they had chosen the patio over the family next door. The judge, a 22-year veteran of civil court who had heard approximately everything, did something neither side expected. She dismissed the defamation claim entirely, ruling that a 47-second video of real events, captured on the plaintiff's own property, constituted protected expression and could not form the basis of a defamation suit. Then she turned the case against the restaurant on procedural grounds, issuing a written finding that the lawsuit itself appeared to have been filed as a strategic attempt to silence a complainant. A textbook slap suit designed to drain the neighbor financially rather than seek genuine justice. She awarded the neighbor $23,500 in legal fees and referred the restaurant's conduct to the city's licensing board for review. The restaurant owner appealed within 30 days. The appeal was denied 6 months later without comment. The patio was eventually closed at 10 p.m. by municipal order. The neighbor still lives next door. She has never spoken to the owner again. The restaurant is still open, still busy on weekends, and still has a 3.5-star average online, a rating that has never fully climbed back. The owner lost the case, the appeal, and something harder to quantify: The neighbor won her legal fees, but not her sleep, not her relationship with the man next door, and not the 2 years she spent in a fight she never wanted, which raises the question that this case has never quite answered. When a business knowingly ignores the harm it causes a family, and a family finally speaks up, is the damage that follows the family's fault, or was it always inevitable?